This meeting of the Littleton Licensing Authority will come to order. Will the city clerk please call the roll?
Chairman Bradish.
Here.
Vice Chairperson Cole.
Here.
Authority Member Odell.
Here.
Authority Member Levere.
Here.
Authority Member Mather.
Here.
Authority Member Peterson. Authority Member Webb.
Here.
Did I get everyone?
One absent.
Sorry?
One absent.
One absent.
One absent. We have a quorum.
Next item of business is approval of the agenda.
I'll move that we approve the agenda.
I'll second the motion. All in favor?
Aye.
I'm sorry, who made the first? Thank you.
That was the approval of the agenda. Approval of the minutes is actually approval of the certification of the video that was taken of our last meeting. We need a motion to approve that, and I'll make that motion.
I don't think there was no certification included in this packet.
Has it been certified?
Minutes. For the last, we'll approve them at the next meeting when Colleen is here.
Okay.
I withdraw my motion. Next item of business, item 9A, preliminary hearing for Pyramid Discount Liquors, 599 West Littleton Boulevard. I believe we have a stipulation in this case. City Prosecutor, would you take us there?
Sure. Good evening. We do have a proposed stipulation that we would ask the board to consider. I would note that the licensee has not actually agreed to the stipulation. It's my understanding that they're going to ask for a little bit more time to review and discuss the options that they have as we proceed towards the show cause hearing. So it's our intention tonight to present the stipulation to the board, ask them to consider it, ask them for their approval pending the licensee's acceptance. And then I would ask that the licensee accept it no later than 10 days prior to the show cause hearing.
And if he doesn't sign it by that date, which would be August 1st, then we would move forward with the show cause hearing on the 13th.
So I'm assuming since you're bringing it forward, you're okay with that proposal, but does that give you any concern about precedent going forward that these may be less likely to be finished when they come to this point?
I'm not necessarily concerned about setting a precedent. I think this case, there's a lot of different, and Mr. Miller could probably speak a little bit more to it. There's a lot of different legal issues that they're confronted with. And it seems like it is a very simple case on the surface, but there are motions that probably would be presented to the board prior to the show or at the show cause hearing, and legal issues that it took us a bit longer than the month. We had a videotape that we had to go over. Mr. Miller and I went over that, several times in various portions of it and had a lot of discussion regarding those issues. So I don't think we're setting any precedent. I just think that this case required a lot more attention than the standard.
And if I may interject, the city's comfortable with this stipulation. I think it's the licensee that is still working with his attorney on that. And in the interest of avoiding us convening tonight and having no stipulation to look at and then coming back for the show cause hearing and perhaps looking at a stipulation at that point or a continuance, I wanted to go ahead and put the stipulation in front of you. If it's acceptable to you and you approve it, then we will provide it to the licensee and give them a limited amount of time to make a decision. And if they don't, we are still on schedule to have the show cause hearing as originally scheduled in August.
I think where I come down on this just intellectually is when we consider the stipulations and we decide if that's appropriate or not, we kind of look for some kind of reticence or remorse or acknowledgement of the actions that were taken. And I'm not sure how the licensee will come before us and provide that and then still hold out hope that they might have alternative methods without, incriminating themselves or.
Licensee's attorney is here, and it looks like he stood up. He'd like to address that, so.
Well, I still have another question yet. What we can do tonight is give this tentative approval for this stipulation or call for a show cause hearing. There's no in between.
Well, so the show cause hearing is already set for August, and what we're asking you to do is approve this stipulation with the condition that it be signed by the licensee before August 1st, and if it doesn't, then the show cause will go forward on August 13th. If he does sign it, then the motion I've drafted will vacate that show cause hearing date, and this matter will be settled. And if the authority, as Authority Member Levere mentioned, if you don't feel like you can get the information you need to make a good decision on the stipulation, then I would suggest that we vote not to approve it, and we'll move forward to the show cause hearing.
Madam Prosecutor, I'm troubled by, and this reflects my comments at the last meeting, I'm troubled by the actions of the clerk. The clerk plainly insulted the police officer. The clerk actively interfered with the police officer's pursuit of his investigation. And I don't see anything in the stipulation that addresses the behavior of the clerk or the actions of the proprietor to discipline his employee as a result of those actions.
There is not anything in the stipulation as to that. I think that's something that the licensee could address. I would ask the board to keep in mind, too, that the employee was charged criminally into municipal court. That case is pending right now. And so he definitely is going to be dealt with through the municipal court on the sale charge himself. As to what the licensee is doing with the employee, we have had some discussions at this point that some of the issues that we've been handling, we have not specifically reflected it in the stipulation at this point.
Can you just, I've been reading through it since you handed it to us, but would you mind just walking us quickly through
Absolutely.
the stipulation and like we normally would, their history and what brought you here?
Yes. I would move to admit, and I believe this was admitted before, but Exhibit A, which is the redacted Littleton Police Department report. The stipulation as presented to the board this evening would call for the licensee to make an admission that on April 17, 2014, at approximately 21:32 hours, licensee sold a 25-ounce can of Bud Ice, a 40-ounce bottle of Magnum beer, a 200-milliliter bottle of Skull vodka to a patron who appeared to be visibly intoxicated. The facts as summarized would constitute a violation of Littleton Municipal Code 3210F and CRS 1247-901. Essentially, the penalty in this particular case, and the city has taken into account all the factors, including the licensee employee's behavior, and the fact that the licensee has not had a violation since, I believe, 2009, and that was for a different violation. It was serving to a minor. We are recommending that a 10-day suspension of the licensee's liquor license be imposed with 5 days of actual suspension and 5 days held in abeyance for 1 year. The 5 days of actual suspension we're recommending, since this is a first offense of this type in the last 5 years, that the licensee be allowed to pay a fine in lieu of the actual 5 days of suspension.
What was the 2009 violation?
2009 violation, it occurred, probable cause was found on January 14, 2009. It was serving to a minor. It, according to the notes, it was a sting, and they sent in an undercover operator, and he or she was sold liquor. It looks like the violation was found in February of 2009. 1 day was suspended, 1 day held in abeyance for 1 year. Looks like prior to that there were no other violations. There was a probable cause hearing conducted in December of 1999, show cause hearing January of 2000, and it looked like the show cause hearing was vacated and the charges were dismissed. Other than that, there's no other record on the licensee. It looks like the licensee, at least according to our records, the transfer of ownership application was completed in 1990.
So if we approve this stipulation tonight, we all sign it, and then there isn't a stipulation, we just go back to ground zero and start over with the show cause hearing.
We'll have the show cause hearing in August.
Stipulation that we signed has no bearing on what we would do in the way of penalty. Should we find that there is a suspension due?
If I may, so if we agree to this tonight, the licensee decides not to sign it, does that bind us in any way at a show cause hearing?
No.
Okay.
No, if the licensee refuses to sign it, I would consider the offer revoked, and at that point, we're going straight to show cause, and pretty much all the powers that the board would have would be applicable to any sort of sentence you would impose.
Well, Mr. Chairman, if you don't mind, should we ask the licensee or the licensee's attorney if he'd like to?
Yes.
If I may just interject one thing too, is that this is completely in your discretion. If you do not want to give them some amount of time in which to agree to sign this stipulation, that is fine. You can have it be that the stipulation is approved, right now, if you will agree to it at this point. So if you're not comfortable with that window, that you do not need, that's just staff suggestion, but it is completely within your.
Well, this is an unusual case, and I would like to hear what's been done or what had been done and what will be done in the future. I think that it may be repetitious if we have a hearing next month to hear the same thing again, but I'm willing to listen as long as procedure allows that. I say, well, you're Mr. Miller, I take it?
Thank you. Chairman Bradish, members of the Liquor Authority, thank you for having us here this evening. My name is Mike Miller. I'm the attorney for Pyramid Liquor. I practice under Colorado Bar Registration number 8407. Just so the authority knows, this city attorney, the city prosecutor, and I have been trying to get together and have been talking about this case over the last 30 days to try and figure out what the offer for the compromise settlement would be. I felt it very strongly that it would be necessary for her to review the videotapes before she made the offer, because I think they're relevant to the degree of visible intoxication, if any. And we had some difficulty on finding a time with her schedule and my schedule where we could do that together. We finally were able to accomplish that. It did take some time. And we only received this proposal for stipulation of agreement and order on Monday, and it was Monday after I'd left the office. So I really didn't get this until yesterday. And I called my client immediately and told him about the stipulation, or the proposed stipulation. But there really just has not been enough time for us to review it, talk about it, and talk about the options in the case. The difficulty that you haven't heard anything about is that the customer that was purchasing the products on the date in question is developmentally disabled. He has a severe disability. And we wanted to talk to him about what his disability was, what might be confused or mimic visible intoxication from that disability, and have a discussion with him. We did, in fact, hire a private investigator. They went out on 3 separate occasions on 3 separate days, trying to track him down, and he's apparently moved from the location where he was living. We have finally found a friend who says they know where he moved to, so we're getting close to finding him. But we need to have that discussion. We also need to know if anything from that disability or any medications he might be taking might affect a PBT, or the test that was administered and that was used for part of the probable cause determination by this authority. So the case has involved quite a few issues that you normally don't see, and we haven't been just sitting down doing nothing. We've been working diligently to try and figure out an answer to this. When I got the stipulation on Tuesday, I talked with the city attorney, and this time it was, I talked to her today, Sheldorn, and said, I thought I would be coming before you to ask for a continuance, so that rather than have you commit to accepting this stipulation without knowing if we're committing to accepting the stipulation, which I thought might not be fair, we would just set it for another day where you would already be here, so we could at least have the preliminary hearing before we went to a show cause hearing. She preferred to just go ahead, since you were here on this matter alone today, to have you review it and approve it. I don't have a problem with that, but I certainly understand your concerns. Why are you asking us to agree to this when you haven't agreed to it? So my preference was to ask for the continuance. I think it was the city attorney's idea to get pre-approval and then give us up to 10 days before the hearing to accept or reject it. So that's kind of where we're at. We're hopeful we'll be able to find this gentleman. I can't promise you we will. I think it's critical to our case to figure out what his issues are before we really are able to properly assess the stipulation.
Excuse me, I'm sure my fault. I'm lacking some clarity. The gentleman that you're looking for, this is the individual who went in and purchased, or the clerk?
He was the individual that went in and purchased from the clerk. He was given a ride home by the police department after that, and they took him to a given address, and we have that address, and he's not living there.
Thank you.
Was he a regular customer of the store?
He was a very regular customer at the store, and he was known to be disabled.
So on this night, did his appearance seem to be different than other evenings, or?
I don't know if we really want to get into the substance of evidence, but I think the evidence and testimony is going to be it was not.
Aside from the actual purchase arrangement, to discuss it with us, if you will, the conduct of the clerk, particularly in regard to the police officer conducting his sworn duties.
I think we'll get into that probably more when we get into the sentencing phase, if we get that far. But I'd be happy to share with you a little bit at this point. The clerk is a graduate of the University of Denver. He's a college student, and he just recently graduated in the top 20% of his class. He had cerebral palsy as a young child, and he also suffers from some other illnesses that cause him to kind of act out at times, and he has medical issues of his own. He kind of acted out on that evening because he felt that a person with a disability similar to his was being treated disparately, and that's why he got upset. Certainly, we've talked to him. Actually, Ms. McCarthy and I both talked to him at great length about you're not going to get through life very successfully if you can't learn to control this kind of behavior. I took him right in to talk to her and let her lecture him just like I did.
So can you tell us, is he still employed with Pyramid Liquors?
He's currently employed there, yes.
How long has he been an employee there? 2 years?
Is the 10 days under the proposal, so do you think that'll be sufficient for you to make whatever determination you need to make?
Well, I guess I'm willing to live with it because that's what I've been offered. My preference was to get a continuance of this and have a little bit more time, just because I don't know how hard it's going to be to try and find him.
And that certainly is an option for the authority as well. If you'd like to continue the preliminary hearing to August 13th, then we'll move the show cause hearing until September.
That would be our preference, but we're willing to do this however you wish to do it. The good thing about doing that is we're not asking you to commit to something that we haven't committed to. And I do understand your concerns about that.
Right, good.
It's a precedent that we're not really comfortable with. We've never done this before, and I don't want to establish a precedent that this is the way we're going to handle stipulations in the future. That's my main concern.
I completely understand.
And I just wonder, aside from whether or not it sets a precedent, I just wonder, it sounds to me like there is a lot going on here, and I wonder if it might be worth, you know, I guess it could go two ways. There's a continuance a month from now. You could be back in front of us, agree to a stipulation, and then we would be able to hear more. You might be at liberty to say more about what's going on, which may help us make a decision. If not, if we end up at a show cause hearing, obviously we'll hear a lot more information. I'm wondering if that might be a better situation so that we all feel like we had the information we needed to make a good decision.
So are you suggesting a continuance or a show cause?
No, sorry. I think I would be in favor of a continuance.
You know, I appreciate all the due diligence that everyone's doing on this. No. So I think that's.
Well, you brought up some interesting points that I would like to pursue before we actually make a decision. And the mental health of the individual that was overserved, I'd like to know more about that. I'm sure you would too. I'm less concerned about the clerk's behavior towards the policeman. He's already been punished for that. It's the overserving, which is a consequence to the licensee, not to the clerk, that we're concerned with here. I'm leaning towards a full hearing.
Rather than a continuance?
Rather than a continuance.
I'm leaning towards a continuance.
So it's clear we are moving for a continuance, if you would be gracious enough to grant that. But if you're not, we're willing to accept the proposal from the city attorney. Not necessarily the stipulation, but the proposal we have up until 10 days before the hearing to make a decision.
Well, for the purpose of discussion, I'm going to make a motion that we continue the preliminary hearing until our August meeting.
And the show cause hearing then
The show
would be
cause hearing
continued to the September meeting.
Continued to September.
Is that a motion?
Yes.
I second that.
City Clerk, would you poll the authority, please?
Chairman Bradish,
No.
Vice Chairman Colt,
Yes.
Authority Member Odell,
No.
Authority Member Levere,
Yes.
Authority Member Mather,
Yes?
Authority Member Webb.
Yes.
The motion carries 4-2 with Chairman Bradish and Authority Member Odell voting no.
But I do want to say, I appreciate everyone making the effort to have the option tonight. So I didn't want to discount that at all.
I'm not disappointed with the vote. I just voted the way I think I should have voted, but we will we'll do the continuance and consider whatever stipulation happens between now and then. And at this time, we won't vote on this stipulation. Next item of business is item 17, reports.
And I think that's just
curious
Colleen.
what that is.
I think, Colleen, that's just the licensing activity report that she provides you with every month
It
on
was.
renewals and.
Yeah.
Okay.
Does staff mind giving us an update? I think I saw in the newspaper, but about the city council did vote for the permanent, or for a ban on retail?
Yes,
Okay.
the city council did pass on second reading a ban on recreational marijuana in the city. And then we do have an ordinance on second reading next week as well to allow the limited transfer of medical marijuana licenses in a very limited circumstance if the new owner is taking the business to a conforming location and they go through the full application process and are granted a license by the authority, then that license transfer can occur. So that's on second reading on Tuesday.
From a medical marijuana licensee to another medical marijuana licensee?
Mm-hmm.
Okay.
Is that Canamart?
No.
Okay.
Canamart is our only center that's in a conforming location right now.
I'm sorry, what's not conform? So there are licensees that are not?
We have three centers that do not meet the distance requirements under our code because they were previously licensed as dispensaries before those were put in place. And the code exempts them from needing to comply with those distance requirements. So the hope is that this will incentivize, if people are looking at buying those businesses, it will incentivize them to move to conforming locations if they're able to transfer that license. Currently, you can't transfer the license in Littleton, so there's no incentive to sell your business or move.
So long as they stay under current ownership, they can stay where they are, but.
Mm-hmm.
Okay.
Yep.
So this is going to be handled exactly like we would handle it for a liquor license?
Yeah, like a new license. We did the Canamart one, I think it was about a year ago, that hearing, but very similar to the liquor license process.
And so that kind of gives them something of value to sell, gives them the right to sell the license. Because there's a limit, there's
There's only 4, yes.
licenses in Littleton.
Mm-hmm.
Authority members have any reports, comments?
I was disappointed with the dates of the turkey leg wine event because I won't be in town. Other than that, no.
So noted.
There being no further business before the authority, I would declare this meeting adjourned.
Thank you.